Good afternoon, Mr. Tyler. Can you hear me?
Yes, I can. Good afternoon.
Thank you. You're a little early, which is fine. We're waiting for someone who's supposed to be here at 1:25. If they aren't here, we'll go ahead and start your case. Well, Mr. Tyler, we'll go ahead and do your case, which is set for 1:35, and then we can always come back if the other people log in. You're early and they're late. This is file number 23218LT. It's entitled Memory Lane Mobile Home Park versus Reginald Tyler. They have filed a demand for non-payment of rent, alleging that your rent is behind and they're asking you to pay the rent or move. As a defendant in a non-payment of rent case, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. And I did send you that information on how to contact legal aid. You have a right to a trial by a jury or by the court. If the action is for non-payment of rent, which this is, and if you are eligible for any legal assistance, you may not need the actual judgment to get that emergency assistance. The summons and complaint should be sufficient, although they may disagree with that, and you already have that. If the plaintiff is agreeable, the Citizens Mediation Services, Inc. may be available as a possible source of case resolution. If both parties are agreeable to mediation, the court can help set that up. If you do reach an agreement with the plaintiff and a consent judgment is entered by the court, you would waive the rights listed above but have the following additional rights. The judgment could not be enforced until 3 business days had passed. You could move to set aside the judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment would be set for a landlord-tenant hearing. However, if the judge did not find in your favor, the original judgment would stand. Mr. Tyler, Mr. Bush has provided me with an accounting sheet that says through March, you owe $4,500 worth of rent. November, December, January, February, and March, and $160 in late fees, and $179.58 in court costs for a total arrearage of $4,839. Now, the law requires that I adjourn this 1 week to give you time to get legal advice or perhaps financial assistance. What's your position? I'm gonna do Mr. Eric, somebody's pounding on his door. Do you plan to move there, or do you intend to stay?
I intend to stay.
Have you asked for any emergency assistance?
Yes,
not much left.
Yes, I sent the paperwork to DHS, and I haven't heard back. I haven't heard anything back from them as of today.
Didn't you get some assistance last year?
Not for rent, no.
Okay, maybe I misunderstood. All right, well, maybe they'll, now the only thing that'll cure this is paying the entire amount of the rent. Now, April 1st, there'll be another $900 rent due and perhaps another late fee. So we're gonna be up close to $5,700. That's a lot of money. You have to pay that within 10 days of April 3rd, or you're subject to being evicted. I'm not sure if they're going to pay that much money. We talked to some people earlier. It isn't easy to find a place to move to. How did you happen to get behind and stop paying rent in November?
I had another heart attack and went back to the hospital to have another surgery on my heart. And when I got out, my lights was about to get cut off. And so I choose to pay my light bill instead of my rent.
All right, well, that's a medical issue, and maybe you will be eligible for any assistance. Were you a veteran?
No.
All right, well, I'm going to continue this to April 3rd at 1:20. This is a tough situation. If they do proceed with this and your tenancy is terminated, you'd have 10 days to vacate. And it's hard to find a place to move to. Ms. Corpening hasn't logged back in yet, but I would suggest you stay in contact with her and let DHS know these numbers, which are going to be 5839 or 4839 plus 940, 5779. It's a lot of money. That would pay your rent through April. And the only thing that'll cure this is paying the entire amount. Do you have a tax refund coming or anything?
No, I'm disabled.
Okay. Well, we'll address this further next Monday at 1:20. You did a good job of logging in early. I'll see you at that time. Do you have any questions?
No, thank you.
All right, thank you.
Good afternoon, Justin.
Good afternoon.
That's a tough one. The medical circumstance, people just, it's outside of their control. Ms. Corpening, we skipped ahead. One of the defendants didn't show up, so we did Mr. Tyler. He indicated he wishes to stay there, and he has contacted DHS, but he's got a substantial arrearage of $57.79 through April. He indicated he had a heart attack and he had another heart attack, and he's in dire straits. I don't know that they're going to come through with the amount of money that he needs, but we'll address the matter further next week. Had you been contacted by any agency to assist him?
I did speak with someone from DHS, and they weren't sure if they could help him. I'm not really sure. They didn't give me any real details, just said they didn't know if they could help him because they didn't believe that he would be able to come up with the money that is needed.
Yeah, let's say they pay 75% of it. I don't know that he has the other 25%, which makes
Correct.
him ill and homeless. He's not a veteran. I would have referred him over to Stony Summit and Veteran Services. So this is a tough case, but we'll address it next Monday at 1:20.
Okay.
Thank
All
you,
right,
Judge.
John. Our next matter is Memory Lane Mobile Home Park versus Reginald Tyler. Mr. Tyler, can you hear me?
What did I do?
Oh my God, Lydia.
Did you exit out of something?
I just hit down here just to get, oh, there he is.
All right, Ms. Richmond, I'll be with you in a minute. Mr. Werber, can you hear me?
Can hear you.
You're here for a 145 matter. And that
That's
defendant is being connected from the Van Buren County Jail. The correspondence doesn't really tell the picture. He's in custody on a first-degree murder charge with a very bad and aggravated set of facts. It's coming to trial, I think, in May. I won't go into the details, but they're quite bad. You can Google it. He's going to be uncollectible for the foreseeable future if he's convicted of that charge. Mr. Tyler, can you hear me?
Yes, I can.
All right, let's pretend we're in a court hearing. I'm going to ask you to take your cigarette out and take your hat off, if you would. This is file 23218LT. We were here last week on March 27th. Mr. Tyler is in difficult circumstances. His rent is substantially delinquent. You just had it in front of me. John, I had the breakdown sheet that we were working from last week, and I can't find it.
Chris, have there been any payments made?
No, there was not.
So another $900 came due. It was 4839.35.
Yeah,
I believe.
we added in 940 for April, I think, and that gives us 5779. Hi, what do you need?
Judge. Oh, nothing, you're in the hearing, I'm sorry.
Okay. Mr. Tyler?
Yes.
We talked last week. We discussed the fact that your rent was quite delinquent. It hasn't been fully paid since October. You're on disability. You had some health problems and we're having some more. And I adjourned the matter until today. You indicated you weren't going to get a tax refund. You don't have any income and you didn't have any source of emergency funds. What's your position here today?
Right now, I had another heart attack last week. I went to social service and put in through them. I haven't heard anything back what they gonna pay to leave me with the balance so I can pay the rest of it. I haven't heard anything back. Also, I'm in the process of moving out.
All right. Well, you get 10, let's calculate that number. 4,500 is rent through March. If we add April, that gives us 4,500 plus 900 is 5,400. And if we add another late fee of $40, that's 200, which is 5,600. And then if we add 179.58, we get 5,779.58, which is what we calculated last week. So you have 10 days from today to move or you're subject to being evicted. Through April. $5,600 in rent. Late is 200. Court costs are $179.58. For a total of $5,779.58. That's due by April 13th, or you're subject to being evicted. Partial payment will not prevent the writ of eviction. The only thing that cures it is paying the entire amount. Do you know where you're moving to?
Sorry, somebody was trying to call my phone. I didn't catch none of that. Sorry about that.
Do you know where you're moving to?
Back to Ben Harbor.
Okay. When you move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving.
Okay.
You have 10 days from today, which is April 13th, to move or you're subject to being evicted.
I'll be out today.
All right, well then go give the keys to Ms. Corpening and the forwarding address, and the issue of money will be determined at some later time. All right, do you have any questions?
No.
All right, you're free to go.
Thank you.
He's just walking around. I don't think he can hear us.
Mr. Mequio,
Yes, Judge.
are you here on behalf of your client in that civil matter?
Well, Judge, not necessarily, I'm not representing Colby Martin in this case, but I am representing him on the murder case pending
I'm
in Van
aware of
Buren.
that.
So I'm just here for information if the court needs it or just to,
Attorney Jeff Werber is here and is totally unaware of Mr. Martin's other circumstances.
And Judge, just so you know, Mr. Macchio, he had emailed me. I just looked at it. I was out of the office last week. So I thank you for the email and the information, Mr. Macchio. But I didn't look at it until 5 minutes before this hearing.
All right, well, I'm struggling with this other guy who's out on a stroll. Mr. Hester, can you hear me?
I could try to call him.
Well, I don't know why he decided this would be a good time to take a stroll.
I don't know. He's out in front of his apartment.
I thought I saw Huss School there in the background.
Would that be Huss down there? Hoppin'.
Hoppin' School. All right, just a moment. Be right back.
Yeah, and the judge just left.
Yeah. Where's the phone?
He's there. I don't know if I should touch it. I don't want to touch anything, but he's just out strolling around on the front yard. I'm going, Tracy.
Oh my God.
I guess I'll take it. That one guy had a cigarette hanging out of his mouth. See, he's right there.
It'd be funny if the judge just walks up next to him and shut.
Hey, you're supposed to, oh, there he is.
Yeah, I've been standing here for the last 20 minutes, but I couldn't hear nothing.
Well, I don't know why you didn't stay in the house.
Well,
It's cold out. You got a
well,
hat on. You're walking down the street. This
I-
is a court proceeding.
Well, I'm running
Um,
late for work, sir. Y'all, I have to be to work at 2 o'clock. I can't be late.
All right, well, you keep walking to, where do you work?
At American Axle?
You have a long way to go.
No, I'm right here. I only live a block away.
All right, well, you keep walking to work. I'm gonna address another matter.
Okay, I'll be inside in about 2-3 minutes.
All right.
Like somebody hit him.
Can you hear me?
Yes. you
Yeah, I
just
can hear you.
walk-
I was talking to my landlord. Excuse me, sir. Yeah, I got into a car accident last week. Totaled my car.
Oh dear.
Yeah, and my other
All
car
right,
not
you
even
keep-
working.
Keep walking. All right. Let's address our next
Can't
matter.
talk anymore, Tracy. How about you do me so I can get down? Okay, he stopped. So that's what he was doing outside.
It isn't in my,
Ah, what happened? Damn. What happened?
I'm gonna put him in the waiting room. Trying to find this case.
Put him in the waiting. Yeah.
It's not in my queue.
Jeez.
Give me one moment.
Oh, no, it's like, I didn't have one.
All right, our next matter is set for 1:45. We're a bit behind, but could be a lot worse. It's entitled Capital One versus Colby D. Martin. Mr. Martin, can you hear me?
Yes, sir.
You're presently in the Van Buren County Jail.
Yes.
It's in that green folder that I gave to Jenny. And also I'm missing this file. We set that for Thursday at 2:15.
Oh, okay.
I'm missing the Capital One file.
Okay, I'll see what I can find.
All right, this is a claim in a civil claim for money damages. Attorney Jeffrey Werber from Weber and Olsees is here, from Weber and Olsees. This is a claim for $5,412.18. Mr. James Mequio is here as a sort of advisory status. Mr. Mequio is representing Mr. Colby in a first-degree open murder case in Van Buren County that is pending trial sometime later this spring. Mr. Mequio, do you have a trial date on that matter yet?
I believe it's the first week of June, Your Honor.
Okay. He had tried to share that information with Mr. Werber, but Mr. Werber was gone, I guess, and didn't get a chance to fully absorb it. Mr. Werber, what's the plaintiff's position regarding this?
So my main question is, because I show a proof of service that Mr. Martin was served on January 21st, 2023. And it gives a description that, you know, from what I can see, meets the description of the defendant. But when was he placed in custody?
He was served in the Van Buren County Jail.
Oh, okay. Well, then that.
Oh, yeah, because it was my understanding, some papers were left at his home, but he was in jail, so didn't receive those. But I don't know if Colby was personally served. I guess I'll let him answer that question.
His mother responded. He's been in the custody since sometime last fall.
Well, if he was served in the jail, then I think we're all set. Service was proper. No response was filed, and I can update my client with his situation. They may just have me close out the file, or they may have me wait until June or July and see what happens in the criminal case and then close it out. But it seems from what everybody's.
I could put the three of you in a breakout room and let you discuss this. Is that acceptable?
That's fine if that's what.
Sure.
All right, I've got some concerns about this, which we'll address in a minute. We're returning to file 221841. I didn't have the paper file in front of me. I was looking at the electronic file. I have it now. The process server, Ms. Darlene Correll, swore that she personally served Colby Martin at the Bliley Road address on January 21st, 2023. I don't believe that's true. Mr. Martin, how long have you been in custody in the Van Buren County Jail?
Since last year. It's been over a year.
And nobody personally served a summons and complaint on you in January of 23, is that correct?
Yeah, you're correct.
Was that the summons, Judge, or a default in January?
No, that's the summons and complaint. I'm gonna show cause Darlene Correll to come in here to find out why she should not be found in contempt for falsely swearing that she personally served a defendant that she did not, but that's a separate issue.
Is there any indication he was served at the jail? I thought there was some discussion.
No, there is not. This is a proof of personal service sworn to by this officer that she personally served him at Bliley Road. And as you know, our local process server, Sergeant Bruce Morse, has an impeccable record, and I trust him implicitly. I have a lot of out-of-county process servers that I do not trust, and I've barred some of them from serving process in St. Joe County. But that's another, he is here, so the fact that the service is false perhaps isn't a problem. But the bigger problem is he's in custody pending very serious charges. To his credit, he and his mother have not ignored this debt. They tried to respond as best they could. And you're here in an advisory capacity. I understand you're not representing them in this civil case. Parties were put in a breakout room. And what did we come up with?
Your Honor, we
go-
did, oh, go ahead, Mr.
No, go ahead. You're the attorney of record, so it's probably best you do it.
We did discuss the matter. Mr. Martin admits that he had the Capital One credit card. He admits the credit card went into default. So I don't think there's any sort of meritorious defense here. He also did tell myself and Mr. McKayo that he doesn't remember being served. So that's consistent with what you stated, Judge. But he did agree to withdraw his motion to set aside based on not having a meritorious defense. And I asked Mr. McQuayo to email me once the criminal matter is done, and I'll let my client know what's going on. And depending on what happens with the criminal case, maybe they close it out, maybe they don't, but we can deal with that after he's sentenced, if he is sentenced at all.
Well, I entered a default on February 22nd. But in true fact, he was not, I entered it on the basis that he was personally served, but he was not. So, Mr. Martin, are you agreeable to allow this judgment to stand that you owe $5,561.20? As a practical matter, you may not be in a position to pay it back for a while, depending on what happens with your case. But are you willing to allow that judgment to stand?
Yeah.
Yes?
Yes, sir.
All right, so a motion to set aside the default is denied. I'll put withdrawn. Defendant was not personally served. As he was in custody. All right, so then the judgment is entered, and I guess then you can decide what you want to do collection wise as you move forward. But Mr. Martin, I'll allow this judgment to stand, and I'm going to separately do an action regarding this process server who swore that they personally served you when they did not.
Your Honor, if you don't mind, could you also provide my office with a notice to appear for the show cause hearing? I'm not familiar with this process server, and I'd like to appear because I'm with you. If they're not doing things proper, I am, we'll find somebody else.
This has come up several times. I had a process server that was getting second summonses and then claimed that he had visited the places, and I set a blanket hearing, and about 22 people showed up, all of whom had not been personally served. I don't remember if I found a contempt with a other sanction, but I barred that process server from serving process in St. Joseph County. And this does disturb me. So I will do an order to show cause to process server because you may not want to use them anymore.
Exactly.
And provide notice to plaintiff attorney.
Thank you, Your Honor.
Mr. Martin, do you have any questions about this?
No, I think I'm good.
All right, thank you. And Mr. McQuail was here and well aware of what happened. although he's not formally appearing on your behalf.
Yeah.
All right, you guys have got other matters to take care of in the spring. I will set up the show cause and if you're needed as a witness, I suppose we could always summon you, but I have evidence that you were incarcerated at the time they alleged they served you, and that should be sufficient. All right, good luck, sir.
Thank you.
Thank you, Your Honor.
Appreciate your time today.
Thanks.